Good afternoon, Mr. Prime Minister. My name is Sonia and I'll be your legal advisor for today. It is brought to my attention that the state of Mandalore is considering to be a party of the International Covenant on Civil and Political Rights. I'll be addressing on two matters today. First of all, what is protocol because of the first optional protocol to the ICCPR, and second is what is reservation because of the suggestion made by the member of cabinet that if the state of Mandalore is to enter as a party to the first optional protocol, it should be done with reservation to the Article 1 of the protocol. First of all, before I explain on what is protocol, it is important to know the law of treaties. Treaties is a well-known component of international law that is somehow similar to a contract under municipal or domestic law. A treaty is essentially a consensual agreement that the parties of international law have accepted in order to establish legal relations that is governed by international law itself. The definition of treaty is expressly stated under Article 2, Paragraph 1a of the Vienna Convention 1969, where it is an international agreement concluded between states in a written form that is governed by international law, whether it's embodied by a single instrument or in two or more related instruments, and whatever its particular designation. Based on this definition, we can see that there are four main elements that shows that an agreement is a treaty. First of all, it must be an international agreement. Having an international character is one of the requirements of a treaty. Secondly, it is concluded between states, which was expressly stated under Article 6 of the Vienna Convention, where it concludes that every state possesses the capacity to form treaties. Third, it must be in written form. The convention does not recognize oral agreements to be a treaty. This can be seen in the case of United States and Gonzales 1986, where the court held that a conversation by phone is an arrangement instead of a treaty. And also, it must be governed by an international law. However, note under Article 3 of the Vienna Convention provides that even if the convention does not apply to an international agreement between states, or if they are not in written form, it does not affect the legal force of the agreement. The states are still considered to be parties of the treaty and subjects of international law. Now I'll be explaining on what is protocol. There are several terms used to signify an international agreement, and all of these are recognized as treaties as long as they satisfy the elements of what constitute a treaty. And the choice of words is entirely up to the parties' discretion. This was expressly stated under Article 2, Paragraph 1a of Vienna Convention under the phrase, whatever its particular designation. Examples of designations are covenant, convention, agreement, protocol, modus vivendi, exchange of notes, and many others. Hence, the word protocol is also known as a form of treaty, a subsidiary to a treaty, or a supplementary convention. In the present case, according to the United Nations Treaty website, the first optional protocol to the ICCPR is also known as additional rights to the covenant, where this protocol allows certain parties to establish a set of rules that goes beyond the scope of the main covenant. Article 1 of the protocol expressed that when a state party to the covenant ratifies the present protocol, it acknowledges the United Nations human rights communities' authority to hear communications from people who allege that the state party had violated one or more of the covenant rights. And also, the committee has the authority to give opinions of these complaints. Take note, it does not extend to those who are not state parties to the protocol, even if they are parties to the covenant, which was expressly stated under Article 1 of the protocol. Plus, they must have exhausted all domestic remedies as stated under Article 2 of the state protocol. Now, addressing the second matter on what is reservation and whether the state of Mandalore can enter into reservation to the state Article 1 of the protocol as suggested by the member of cabinet. According to Glenn McGrory in his article, he views that the making of reservation to multilateral agreements, particularly those pertaining to human rights, is one of the most contentious topics in modern international law because it puts the concept of individual state sovereignty at odds with efforts to create a universal public order. They are typically used to either restrict the duties taken on by the reserving state or to enable the performance of the treaty obligations through equivalency. According to Article 2, Paragraph 1d of the Vienna Convention, reservation means a unilateral statement, however phrased or named, made by a state when signing, ratifying, accepting, approving, or acceding to a treaty, wherein it intends to modify or exclude the legal effect of a specific treaty provisions when applied to that state. When a state announces its willingness to be bound by the treaty terms, is subject to a reservation, the state is basically attempting to change the terms of the treaty. Hence, from this definition derives three main elements of reservation. First, unilateral statement, however phrased or named. This means a state cannot disregard its unilateral statement, which amounts to a reservation, just by calling it something else. There is always a confusion arising from declaration and reservation. Hence, the Guide to Practice on Reservation to Treaties, or GPRT, provides guidelines to distinguish both of these terms. Firstly, under Guide 1.2, declaration is also known as a unilateral statement, which is particularly similar to reservation, but it is to specify or clarify the meaning of the treaty or its provision, whereas, as mentioned before, reservation modifies the treaty provisions instead. Reservation can be differentiated from declaration and based on few methods. As per Guideline 1.3.3, for the statement should be interpreted with good faith, following the ordinary meaning of its term. Second, identifying the intentions of its author. And third, phrasing, whether it excludes the provisions or clarifies the scope of the treaty. For instance, in the case of Bellilos and Switzerland, 1988, the European Court of Human Rights held that the interpretation declaration made by Switzerland under Article 6.1 of the Convention amounts to a reservation. However, the court found that the reservation is invalid since it shows a general character which does not satisfy Article 64.3 of the European Convention on Human Rights, also known as ECHR, and now it's under Article 57.1 of the ECHR. Now, the second element deriving from the meaning of reservation from Vienna Convention, it is made by a state when signing, ratifying, accepting, approving, or acceding to a treaty. Under the Guideline 2.3 of GPRT, a state may not formulate a reservation to a treaty after expressing its consent unless it's stated otherwise by the treaty or not objected by other contracting states. In addition, Article 19 of the Vienna Convention also explains the fundamental rules to the formulation of reservation, where a state may do so except when it is prohibited by the treaty provided only for specified reservation which does not include the particular reservation, and if it does not fall within the subparagraph A and B, then the reservation is incompatible with the object and purpose of the treaty. And finally, the last element is it intends to modify or exclude the legal effect of the specific treaty provisions when applied to the state. At the present scenario, neither the ICCPR Covenant nor the first optional protocol to the ICCPR have any clause in relation to reservation. Nevertheless, it was proven that there are state parties who had made reservation to the first protocol since almost 24 of them had done so, according to the status report of the first optional protocol. The government of Trinidad and Tobago, for an example, re-acceded to the first optional protocol to the ICCPR with reservations to Article 1, which is similar to the scenario where Mandalore chooses to accede the protocol with a reservation to Article 1. The reservation states that the United Nations Human Rights Committee is ineligible to receive or consider complaints regarding any prisoners who's serving death sentence in relation to any issues involving his or her arrest, custody, trial, punishment, or any other issues related to it. Technically, by barring requests from those who are now facing death penalty, they are attempting to modify or exclude the legal effect of Article 1 through reservation. On the question whether the particular reservation was valid or not, it is important to assess the compatibility of the reservation according to Article 19 of the Vienna Convention. Traditionally, reservations will be considered valid if it was consented by the contracting state parties, where in some cases the parties will agree because of the belief that if they are willing to do so, why not? But now, in accordance to Article 9 that was mentioned before, Article 20, which establishes the rules on the acceptance and objections of reservation, and Article 21, which explains the legal effect of the reservation of the Vienna Convention, a reservation may be made unless it is not rejected by the treaty itself and it is compatible with the purpose of the treaty. The landmark case on this is Reservation to Genocide Convention 1951, where the court rejected the traditional approach and suggested that the test of compatibility, if a state's reservations is in line with the convention's objective and purposes, it may be considered to be a party to the convention despite the objection of one or more other states, but not by others. Similarly, in Royal Kennedy and Trinidad and Tobago, as explained before, the committee viewed that it was their task as the treaty body to the ICCPR and its optional protocol to determine whether a specific reservation was compatible with the object and purpose of the covenant, to which they determined that Tobago's and Trinidad's reservation, which excludes the committee's competence under the protocol, is incompatible with the goals because it prevents a specific group from receiving greater protection that which is available to the rest of the population, and this will amount to discrimination, thus going against the basic principles of the protocol. Hence, the consequences of an incompatible reservation will be severable generally, and even though the reservation made by Trinidad and Tobago is invalid, they are still parties to the covenant. They are still considered parties to the covenant without the benefit of the reservation, as stated in General Comment 24, paragraph 18. Similarly, in the case of Loizido and Turkey 1995, the European Court ruled that Turkey was still a party to the European Convention, notwithstanding Turkey's obvious indication to the contrary. Therefore, it all comes down to the intention of the reserving party, where Trinidad and Tobago intends to still remain as the party to the protocol when they have re-acceded to the protocol itself. In conclusion, if Mandalore, upon acceding to the protocol, made reservation with respect to Article 1 of the protocol, firstly, it must be excluding or modifying the legality of the particular provision as per mentioned by Article 2, Paragraph 1d of the Vienna Convention. Hence, it should not be of a general character. It must be more specified. However, it must be compatible with the object and purpose of the protocol, and an incompatible reservation does not affect their position in the covenant. Finally, it is a human rights treaty. The UN Human Rights Committee should have the competence to determine the compatibility of a reservation with the object and purpose of the covenant. Additionally, if the reservation made by Mandalore is incompatible, They have the choice to modify it or to make it more compatible or simply withdraw from the covenant. And I would like to end it with a quote, "May the force be with you."